Hi, my name is Mark Biernath. I'm an estate planning attorney here in the Atlanta area. We're in the middle of our discussion on decision making for incapacitated adults. We've already looked at the use of powers of attorney and healthcare powers of attorney, or Georgia's Advanced Directive for Healthcare, in those contexts. Now we're going to take a quick look at the use of revocable living trusts. Revocable living trusts are very powerful tools and can serve a number of purposes. But for our discussion here, we're only going to focus on the ability to use a trust in the context of decision making for an incapacitated adult. In order to do that, we're going to go back out to the seminar in Summerville, Georgia.
Now, we talked a little bit about trust earlier this morning. Going to kind of cover some of the issues here as well. But here we're looking at for you, if you are incapacitated. And I talked about a thing called a revocable living trust. And this is another way to pass assets upon death. Most people think of a will as how to pass assets upon death. Another way to do this is a revocable living trust. And a trust is simply a private agreement between a grantor, a trustee for the benefit of the beneficiary. And as I said earlier, in Georgia, the grantor, the trustee, and the beneficiary can all be the same person. So you can create a trust for yourself where you are the trustee, you put your assets in the trust, and you are the beneficiary. And the benefit here is, okay, number one, you have to have capacity. And the assets, you have to have assets that can be owned by a trust. So certain assets cannot be owned by a trust by law. Those generally are IRAs, 401ks, retirement type assets. You cannot transfer your own IRA into a trust while you're alive. When you pass away, the proceeds can go into a trust. That's not a problem. It's only while you're alive, because of the tax deferred benefits to that IRA, you're not allowed to put it into a trust. But real estate can be put into a trust. Investment accounts can be put into a trust that are individually owned. And where it becomes helpful to have those assets in trust is if you become incapacitated. We're not relying on powers of attorney to manage those assets. We have it in a trust. And banks accept and respect the authority of a trustee. One of the main reasons why the liability for that trust rests with the trustee, not with the bank. So the trust is a way to shift that liability, and the bank is more than willing to work with those, with the trustees. So the trust can be established for yourself, can be established for someone else. Here we go back to the special needs trust, where you can set money aside in a trust for someone else. And then the important part for the disability or the incapacity planning is you can nominate a successor trustee in the event that the initial trustee becomes incapacitated. So let's take, for example, your own trust. If you become incapacitated, you can have your spouse step in to serve as the successor trustee. Now, generally, the way I do it with a husband and wife is I make both husband and wife the trustee of both trusts at the very beginning. That way we don't have to prove that somebody's incapacitated before. But generally, when we want it to go beyond husband and wife, we want to have some proof that the incapacity has occurred. And generally what we do is we get two doctors to sign off that John Smith is now incapacitated and Jane gets to take over as trustee. But this is a great way to manage assets, but you got to have the right kind of assets that can actually be titled in a trust to take advantage of that. But someone can step in, manage the assets of the trust without court intervention. That's key. I love the courts. I love the judges. Every judge I've been in front of, at least in the probate world, have been very good judges, and they have a great heart. They want to work with the families, especially the families I work with. They don't have a whole lot of patience for when mom's in the nursing home and the kids are fighting over the money. They really don't have a lot of patience for that. But when it's mom and dad coming in and they have a child with a disability, you know, they want to help you. They want to make sure you have what you need to have to do what you need to do. But that being said, court's expensive. It's a hassle. Most people don't like going to court. In fact, the only people I know who like going to court are the attorneys. And that only when they have billable hours to collect, when they're done with court. You know, they're not there because they like going to court, they're there because that's how they make a living. So if we can keep the court out of things, it keeps things less complicated and cheaper.
Revocable living trusts are very powerful tools, and the few minutes we've spent discussing them here does not do them adequate justice for all the things that a trust can do for you. We will take some time at a later date in order to discuss them much more fully. Now we're going to shift our attention to the issues of guardianship and conservatorship here in Georgia. So please join us.